I don't know how many of y'all have ever heard this. When you start really doing a lot of liens, this part kind of becomes old hat in your mind, and you don't think about it a whole lot anymore. But this is important consideration in determining whether or not the materials that are either physically installed or improvements are physically made waiting to be installed on the real property. For me, this doesn't come up a whole lot, but every now and then, all of a sudden it'll come up and you'll start wondering, well, wait a minute, does this actually fit into the statute and making sure that you can lien it on the property? Especially fabricated material is typically defined as a material fabricated for use as a component of the construction or repair, so as to reasonably unsuitable for use somewhere else. When this happens, so this happens a lot when a job is canceled, for example, and I'll give you an example of like a construction component that this would have to be an example for. So someone makes a granite countertop, and once the slab of granite is cut to the required dimensions of a specific contract, and perhaps they even cut out like a sink in it, what are they going to do if they're not able to use it for a different job? That is where a specially fabricated material comes into place. A lot of states have rules that provide that a person who specially fabricates materials has a lien, even if the material was never delivered to the project. Further, the lien secures payment for the specially fabricated material, even if the material hadn't been delivered or incorporated into the construction or repair, lest its fair salvage value. So if they can sell it for something, then it would be less that value, but they can lien for the value that they cannot get. We have a couple attachments that should be attached to your the paperwork that was provided to you, and one of them is attachment A. This is something I just put together from a few states, and it shows what some of the differences are in various states and how they handle specially fabricated materials. I will say that most states handle it very similarly. Florida, as an example, the courts have carved out an equity exception to the general rules for specially fabricated materials, provided they are lienable, even if they never arrived to the job site, so long as the materials were manufactured to order and the non-incorporated is the fault of the property owner. Massachusetts has a special requirement for those supplying specially fabricated materials, and while the statute doesn't clearly provide that the mechanic's lien could be placed even if the materials were not incorporated, the statute infers the same. Tennessee includes the definition of furnished materials to specially fabricate materials for incorporation in the improvement if not delivered to the site of the improvement and are not readily resaleable by the liener. And Ohio is basically the same way. So there's a few more states in here that I provided an example for, but basically most of the states are saying that there is an exception that is specifically carved out for specially fabricated materials. And you might look and see if your state is on there as well. And my guess if it is not on there, that it probably have the same type of law as well. The next question and factor to consider when filing your lien is this a residential or is it a commercial project? Residence means a single family house duplex, triplex, or quadruplex, or a unit in a multi-unit structure used for residential purposes that is owned by one or more adult purposes and used or intended to be used as a dwelling by one of the owners. So it came up, for instance, recently, like, one of those high-rise condos where people are purchasing units. Would that be considered residential under the mechanics lien statutes? And I believe using this definition as a key, that would be a residence. The one unit that is being like remodeled or whatever would be a residence. If residential, for instance, does the project have homestead protection? So I think it's not really hard to determine whether or not something is residential versus commercial. But where it gets kind of difficult is determining whether or not something falls under a homestead for a residential project. You have to understand the distinction between whether or not the residential property is homesteaded or not homesteaded. And it's important to determine whether your state is going to allow a lien claimant to foreclose on a residential property that is homesteaded. This is something in my state that is really up in the air. There's a lot of attorneys that say, yes, it's okay, and there's a lot of them that say, no, no way. And in fact, the judges seem to be all over the place as well. So I would say that if you are going to try to foreclose on a homestead in your state, that you try to find some specific case law that has allowed the foreclosure, because even though I think a lot of the lien laws kind of generally seem to allow it, there's also the other side of that coin, which says that homesteads are generally protected. As an example, I looked into this for California, and there's a lot of case law for California that talks about creditors being able to force sales of homesteads and being able to take, their share. They have a formula that they're using in California, but it really doesn't talk about what happens if there's a lien, for instance. There's a lien, a mechanics lien. How does that play into it? So, liens have their own different laws generally in different states, and I think that, you will have resistance if you try to foreclose on a homestead lien, as an example. But we're going to go through this just where you can try to figure out whether or not it's homestead, because my suggestion to you would be to just try to say it's not homestead to begin with, and to try to get it out of the homestead realm. And to me, that has been much more beneficial in my practice than to even say that it's homesteaded. There's like several caveats that you can sometimes use to try to think outside the box and argue that these homes are not homesteaded. For example, what about homes that are being built with the intent to live in them as a homestead at some point, but they aren't homesteaded when they are being built? For example, perhaps the owner is currently residing in another home. So what if they're using another home that they have homesteaded, but they are building a home? If they're building something but they're living in a home that's homesteaded, I would always argue that the home that they're living in that's homesteaded is their homestead, and that I can go after the home that they're building and sell it and sell it. So, and that it is not homesteaded. That's your first argument against homestead. The second argument is that what if the homeowner sold their property their homesteaded property and they are living in an apartment, as example, while they are building their homestead. Some people are going to argue that, well, that the new property is my homestead, but they're not living in it. And most homestead laws say that they must be living in it and using it as their homestead. So my argument would also be they're not living in it, so it can't be their homestead. And I would also argue the same way that it's still not their homestead because they're not living in it. Next question would be, what if they are building a home but they have it being built under a corporation or a trust? There is a lot of case law that says that, you know, the residence must be owned by a person. Let me go back. This must be owned by one or more adult persons. Well, a corporation or a trust is not one or more adult persons. So to me, I think that you can always argue against homestead, and I'm talking about not homestead exemptions for the purposes of taxes, but homesteads for the purposes of lien rights. And I think that you might be able to get around the homestead lien rights and go ahead and go through foreclosure because they have it under a corporation or a trust. I see a lot of spec homes that are residential, but it still doesn't meet the requirements of being owned by a person. So if it's a spec home that they're trying to sell, you would always argue that that's not a homestead as well. So as you can see, these are really fact intensive. You have to, you know, take what the property is and try to argue it all the way around and see if you can figure any argument that you can that it's not a homestead, and get around any homestead argument your state has that enables you to try to foreclose on it or that kind of thing. My assumption in this particular part of the CLE today is that your state would have some laws that would make it difficult for you to foreclose on a homesteaded property. I think that there are a lot of states, and a few of them that I've looked up, like Florida, for instance, that are going to make it very, very difficult for you to foreclose on a homesteaded property. So if you live in one of those states, it's going to be very beneficial for you to try to argue around the homesteaded exemption for the purposes of the lien.